Good morning, all. I'd like to thank you all for joining our annual Data Protection Masterclass. Unlike last year, we're not benefiting from croissants and coffee in the Shelburne, but I see many have turned out in numbers, so I really appreciate that. My name is Philip Nolan. I lead the privacy and data security team at Mason Hayes and Curran. And this morning, I'm joined by some of my partners, including Oisín Tobin, who leads our San Francisco office and is also a member of the privacy and data security team. Also, Rowena Fitzgerald, my partner in the financial services regulation team, will be participating along with my corporate partner, Claire Lord, who leads our corporate governance and compliance team. So we have an interesting morning planned for you. But basically, what we want to do is cover two things. First, Oisín and I are going to do a kind of a whistle-stop tour of what's happened in 2020 and really just tell you what's been crossing our desk and what's been really keeping us busy over the course of 2020. And in the second part of our seminar, what we want to do is we're going to pass you to Claire and Rowena, who are going to talk about how organizations are grappling with the governance issues and the oversight of risk when it comes to the handling of data in organizations. So that's the plan. In terms of housekeeping, well, first, thanks for partaking in the poll. I see plenty of you have engaged with that. There's also an opportunity to raise questions over the next hour, so you can send your questions through using the questions bar at the bottom of your screen. And as I said, we'll try and address some of the answers, to the easy ones at least, at the end of our presentations. So yeah, without further ado, let's talk about the GDPR. So we're 2.5 years into the operation of the GDPR now. And as we were thinking about preparing for this seminar, I mean, it's best described the GDPR as having kind of 3 periods so far. The first being the frenetic preparatory phase coming up to May 2015, when everyone was getting compliance documents put in place. After that, for the next kind of 12 to 18 months into 2019, there was a sort of a lull where not too much was happening, and there was a bit of wait and see and wondering why all that compliance work. And now we're definitely in what we call kind of the third phase, where there is quite a significant amount of enforcement and civil plaintiff litigation kicking off we saw it kicking off in particular in 2020, and we think this is the phase which is going to continue for some time. I mean, when we talk about enforcement, what exactly do we mean? Well, we're talking about DPC engagement. Last year, we saw the first fines. We saw 2 fines issued against TUSLA, the Child Protection Agency, and shortly after that, 2 subsequent fines. So we saw 4 GDPR fines being issued by the DPC, but that certainly is only the tip of the iceberg, and we expect many more fines will issue this year. Why is that? It's because there are, I think, approximately 27 international cross-border inquiries being conducted by the DPC at present, and in addition to that, another 56 domestic inquiries. On top of that, you have about 15,000 security breaches have been notified, and many other thousands of complaints have been submitted by data subjects concerning all types of issues, including direct marketing, rights of access, rights of deletion, possible unlawful sharing with third parties. So the DPC is very busy and have been very active. I suppose the second thing, which is trend, if you like, general trend of 2020, has been the proliferation of a large amount of guidance from the DPC and from the European Data Protection Board. And that's been keeping us really busy. And it's quite a challenge in itself to keep up with all of the guidance which continually issues. It's often deceptively cold guidance, but regulators consider it as very important and expect organizations to be aware of the guidance, to understand it, and to be complying with it. And often guidance which looks to explain vaguer parts of the GDPR tends to be quite conservative and onerous for the parties affected. So over the course of this talk, what we hope to do is to touch on some of the guidance that has been issued by the DPC and the European Data Protection Board recently. So moving on, and I guess towards the end of last year, a lot of the guidance issued concerned data transfers. So that's the first kind of substantive thing I want to talk about before handing it off to Oisín. And undoubtedly, one of the most topical issues in 2020 concerned data transfers. Data transfers affects all organizations. All of you who are on the webinar today will work with organizations who are transferring data outside of the EEA. It's an essential part of doing business. And what we had in July of last year was the handing down of the CJEU decision in the Schrems 2 case. And essentially what that case found were 3 things. First, the case decided that the Privacy Shield, a very important mechanism used by many European companies to transfer data to the US, was invalid. So as of the date of the decision, one could no longer use the Privacy Shield. Secondly, and somewhat helpfully, the court found that standard contractual clauses, which are used by 80+% of Irish exporters, were valid and continue to be valid. However, the third finding, and the tricky part, was they said, when organizations are using SECs, they must carry out a type of assessment, which we now call a transfer impact assessment. So in addition to simply signing SECs when you're going to transfer information, be it to India, to Singapore, or to US, you're also expected to carry out an assessment before you carry out the exports, which involves considering the law of the importing country and assessing that law and the surveillance and the government access rules against the protections contained at European law and European Charter. Secondly, then, insofar as any deficiencies or shortcomings of the law of that importing jurisdiction exist, you're expected to adopt supplemental measures. In addition to the contractual safeguards in the SCCs, additional supplemental measures must be adopted by the data exporter in concert with the importer. And then thirdly, in deciding what those supplemental measures are, you have to take account of all the factors and circumstances surrounding the export itself. So that's a pretty onerous test. So previously, we had companies simply signing SECs, that's fine, I can transfer information to the US, Singapore, India, and everywhere else, but that's certainly no longer the case. So what were the reactions to the case? Firstly, in terms of businesses, well, businesses continue to use the SCCs because they had one less tool to use with the invalidation of the Privacy Shield. However, from July, we started working with our clients in preparing transfer impact assessments because, as I said, if you're going to use SCCs, the expectation is that you have a transfer impact assessment, which are quite onerous and involve a reasonable amount of work and diligence before one transfers data overseas. The second reaction we saw was amongst the regulators. And the big question was, well, what are these supplemental measures which organizations need to adopt if there are perceived deficiencies in US law and in Indian law, Singaporean law, South Korean law, wherever the jurisdiction is, when those jurisdictions' laws are measured against the Charter and the GDPR in Europe. And the guidance issued in November concerning from the European Data Protection Board on what these supplemental measures should look like is very challenging and quite conservative and very onerous for organizations to comply with. Helpfully, the guidance is still only in draft form. A lot of submissions were made by organizations, a lot of complaints made by organizations as to how unworkable the guidance issued by the European Data Protection Board is. And we have to simply wait and see for those recommendations to be finalized. But just to give you one or two really quick examples, I mean, some of the suggestions that came from the European Data Protection Board were that your standard sort of in an international company where you have like a global employee directory, and insofar as that's your folks in New York and folks in Chicago accessing a directory of employees in Europe, the suggestion in the guidance has been, in the draft guidance, has been that would be unworkable in many jurisdictions. Similarly, it was said that in terms of lots of transfers to the US and to other jurisdictions, the expectation will be that the data, when it gets out there, is fully encrypted and essentially unavailable in non-encrypted form to the importer, which doesn't really make much sense. I mean, why would you send it overseas if the overseas entity can't access it? So the guidance is extremely strict. And I guess in terms of other more helpful reactions to the Schrems 2 case were some political developments. Two I'll mention. Firstly, helpfully, the US and the European Commission have started work on a new arrangement which will replace the Privacy Shield. And with the new Biden administration taking over today, one would expect that will be a serious part of the administration's work, and we hope that there will be a new Privacy Shield arrangement. Secondly, the European Commission have also tried to give effect to some of the elements of the Schrems 2 decision. So what we have are new draft SECs, which issued last November, and we expect they might crystallize into final form new SECs reflecting the decision over the next couple of months. And companies will have 12 months to use those SECs and essentially to terminate their current standard contractual clauses and to implement these new SECs. And they go some way towards addressing some of the challenges in the Schrems 2 decision. But this issue of supplemental measures is going to persist, and we really just have to watch and see what happens. So that's it on transfers. And I think I actually deliver that piece on time, Oisín. So I'm going to hand it over to you. And just, Oisín, I think it might help folks attending. If you just, I mentioned enforcement earlier, if you just build out that point around enforcement and explain what sort of enforcement work you've seen in the last 12 months. Thanks.
Yeah, absolutely. Thanks, Philip, and good morning, everyone. And yes, you are on time, actually, slightly ahead of it. Okay, everyone, I want to talk about kind of two related issues. I want to talk about security breaches, and I want to talk about a question that I get asked all the time by clients, which is what's our fine exposure if we breach the GDPR? So what's the financial risk to the business or the organization? Let's talk about fines first. For years, lawyers have been talking to their clients and scaring their clients with threats of 4% of global turnover fines. I'm guilty of this as well. So we're 2.5 years in now. Are those fines being imposed? Not really is the short answer, or at least not yet. Well, we're seeing a couple of interesting developments in the penalty space I want to talk about. First one is that there is a real divergence in approach across EU member states with respect to how many fines they're imposing. In Ireland, as Philip alluded to, the DPC has so far handed down a total of 4 fines. 2 of those were against Tulsa for 75,000, 40,000, both for security breaches. There was one of 65,000 against Cork University Hospital for having insufficient security in place around patient records. And Twitter was also fined €450,000 near the end of last year for a security breach, which we might talk about again later. So I guess the first takeaway here from the Irish perspective is the fines seem to be coming down mainly in security breaches. And we actually see a similar trend in the UK in particular, where a lot of the fines are really for security incidents as opposed to more technical violations. That said, I want to do a bit of a comparative analysis here. So we have 4 fines in Ireland. How does that hold up, or how does that look against other jurisdictions? Well, we're kind of at the lower end with respect to the number of fines imposed. So, by way of contrast, Austria's handed down 10 fines in the same period of time. Germany's handed down 28. Italy's handed down 40. Spain, my favorite, has handed down 173. So we are seeing a lot of more fines being imposed in most other member states. The other thing that said, I should probably add one note of caution here, which is that possibly the reason we haven't seen as many fines in Ireland isn't because the DPC is laxer. It's more, I think, that they're being more careful with respect to how they're putting their cases together. So I do think that we may see more fines in the coming year, and particularly larger fines as some of the bigger cases progress. So that's the first thing. We're seeing different approaches to fines, different markets. Second thing to note is that there is a real lack of consistency in terms of how fines are being calculated and assessed across Europe. This is really well documented by the Twitter breach that I alluded to earlier. So as I said, Twitter was fined €450,000. Now, because Twitter has cross-border operations, for various technical reasons, the DPC needed to get that fine signed off by the European Data Protection Board, which is effectively the collective body of European regulators. The DPC initially went to the European Data Protection Board and proposed fines of between €135,000 and €275,000. Now, quite a number of EU regulators objected to these fines, saying they were too low. What's interesting is how much larger some of the other proposals were. My personal favorite is the Austrian Data Protection Authority, which suggested that the fine should represent 1% of the Twitter group's global annual turnover, which at the time would have been about 30 million, around $30 million US. So that would be a fine of $30 million US. So you've got an Irish fine proposal of 135 to 275 grand, then you have an Austrian proposal of 30 million. Similarly, the German regulator, or the Hamburg regulator, which is the German representative, suggested a fine of between 7 and 22 million. So what you're seeing here really is a real spectrum of fines that are out there. So what are the takeaways from this? Well, I think there's 2 that are worth bearing in mind. The first point is that even though the GDPR has specific principles that are to be taken into account with respect to the setting of fines, those principles are extremely open-ended, and there is a radical divergence of views with respect to how they're going to be applied. So at this point, we don't have much certainty around what the fine exposure really is. Second point to note practically is that the Irish fines seem to be lower than those being imposed in other states, at least when you look at the Twitter case. So that's the sort of fining part of the Twitter case. The other the other point I want to talk about with that case is what it means for companies undergoing security breaches, because I think there's some really important lessons in this in this decision from the DPC. Now, the decision itself runs to 188 pages. And I think this is a case where, we'll say we read it so you don't have to. I think that 188 pages can effectively can be distilled down into two principles. But first, I want to talk very briefly about the facts. And in abstract, the facts are pretty simple when you cut through all the noise. Effectively, Twitter Ireland uses Twitter, or Twitter International Company, the Irish company, uses Twitter Inc., based in San Francisco, as its data processor, which is a very common arrangement. A security breach occurred, which Twitter Inc. became aware of, but it didn't notify Twitter Ireland for a number of days, largely due to the Christmas holiday. Then once Twitter Ireland became aware of the breach, it filed a notification with the Irish DPC. Within the 72 hours, actually, they notified it within a day. So the issue here was effectively, the first issue was whether or not Twitter had timely notified the DPC. Now, Twitter Ireland, the controller, argued yes, they had. They became aware of the breach and then they notified the DPC the next day, very much within time. However, the DPC said, no, that was wrong. And in so doing, they've made a finding that I think is really important for all companies that employ data processors. What the DPC held was that as a general rule, controllers become aware of a breach when they're actually aware of the breach. So controllers have to actually know about the breach in most cases. But it seems there's an exception to that rule, which is that if the processes in the processor break down such that the controller ought to have been notified but wasn't notified, then effectively the controller will be fixed with constructive knowledge at some earlier time when they should have become aware. So in this case, because Twitter Ireland should have become aware earlier of the breach, they were fixed with knowledge of an earlier, they were fixed with constructive knowledge from an earlier time, and as a result, they were fined 450,000. So that's a very important takeaway. It means that if you outsource things to your processors and they're aware of a breach, you need to find out really quickly. You can't say that you're not aware until they're aware, until they tell you, if the notification process breaks down. The other point in this case, which I'll deal with briefly, is the idea of the maintenance of a breach register. And a breach register is effectively the internal log of breaches that have occurred. And if you'll let me quote the legislation for a moment and bear with me, Article 33.5 of the GDPR says that the controller needs to document the breach, comprising the facts related to the personal data breach, its effects, and the remedial action taken. And in this case, Twitter effectively did that, but they ran into difficulties for a couple of reasons, one of which was that the DPC took a really broad reading of what it means to maintain a breach register. And they effectively read additional requirements into the law. And they said that in addition to the stuff that's expressly required by Article 33.5, your breach register also has to have your initial risk assessment and any reasons for the delay in notification. So what's the practical takeaway here? Well, I think that companies that maintain breach registers, which is a good practice, should look at those to make sure they're actually capturing all of the relevant information in one place. You don't want to be in a situation where you have a register that only has incomplete information and then you get fined or you're exposed as a result. Okay, so that's what we're seeing on the regulatory enforcement side of things at a high level. Philip, the other thing that's kind of coming up a lot is civil litigation, at least threats of civil litigation. Could you talk a bit about what we're seeing in that space?
Sure. I will, Oisín, briefly. Just one point, kind of picking up on some of the points you made earlier. As you said, we're seeing a lot of larger fines emanating from other European regulators, and a lot of those are jumping from regulatory fines into the courts. And what we've seen in the last couple of months in both Germany and in Austria, we've seen senior courts in those jurisdictions actually overturn some of the larger regulatory fines issued by regulators in those countries. So that's certainly interesting to show that, it shows regulatory fines are not the end of the road, and the ultimate guidance may end up coming from courts as much as it may come from the European Data Protection Board. But yeah, Oisín, just to mention in brief, I mean, the parallel risk financially for organizations when it comes to GDPR compliance, in addition to fines and other corrective measures issued by regulators, is the risk of plaintiff litigation. And as a lot of you will know, Article 82 makes it clear that any individual who suffers a wrong under the GDPR has a right to compensation for both material and non-material damages. And it was that expression of non-material damages which has always caused a lot of concern amongst organizations. And the question arises, well, have we seen any guidance as to what non-material damage means? And unfortunately, the answer is no. There's certainly a lot more plaintiff litigation occurring around Europe, including in Ireland, but we've yet to get any good guidance as to what non-material damage is, such to enable a court to award compensation. Helpfully, with some cases that we've seen coming out of coming out of Austria and Germany, what they have said is they're really pushing plaintiffs to prove non-material damage, whether that's inconvenience or psychological harm, before making an award. So there's no like automaticity. There's been a breach, you're entitled to non-material damages and compensation for non-material damages. So that's helpful. There seems to be some sort of a bar emerging. I guess the other trend in terms of civil litigation is that it's happening, and there's certainly far more of it now than there was, we say, 2 years ago. And there's quite a number of cases, some reported, some not, happening in Ireland. As far as I know, nearly all of them either are ongoing or have settled, and we've very little by way of decision to guide us. And it's unsurprising as to why they're settlements, because often the claims are for relatively small sums, whereas the cost of litigating these often complex issues, such as non-material damage, can be quite high. People are invariably asking, so what would a typical claim get, for someone affected by a security breach? And to look abroad at some of the compensation awards made, if you look to the Netherlands, which is the courts are pretty rational there, if you like, and the claims, the compensation award has been around, for amounts of 850, 950, 1,000 euro for successful claims. So that's all fine. And you could say, well, we needn't worry about that too much. The one point to understand is that even if in Ireland that becomes some sort of a benchmark, also, there's always a risk of class actions. And if there's a breach affecting a class of 10,000, and let's say 5,000 of them join a class, and a not-for-profit organization acts for all of them collectively, well then obviously if each is receiving an award of 1,000, potential liability can rack up. So it remains a persistent risk and one to be aware of. And I think we'll see more jurisprudence on that in due course. Just switching tack a little bit now to more substantive issues. And again, asking ourselves what has been topical in 2020. I want to mention the area of minors meaning children or those under 18. And this is undoubtedly an area which the DPC has signaled will be one of priority for 2021 and beyond. And I guess that signaling was best manifested late last year in two respects. The DPC launched two parallel inquiries into Instagram, investigating its treatment in relation to the data of minors. And secondly, just before Christmas, the DPC issued a consultation with a view to ultimately preparing guidance for organizations in terms of how they process the data of minors. Invariably, what we find in advising our clients is that once you kind of look under the bonnet, most organizations are processing the data of those under 18, and it's almost inescapable. So when you look at the proposed consultation and what's been published by the DPC, and then if you look at what the ICO, the UK regulator, are doing, and they're the most advanced in Europe, they'll have a binding code of practice adopted later this year. A couple of trends are emerging which you need to be aware of. First, you need to be thinking about your privacy policy and asking yourself, is this good enough? Is this clear enough for those under 18? Will a 15-year-old, will a 16-year-old understand what it says? You have to look at your products and ask, well, are our products and are the privacy controls in our products, are they good enough for minors, and are they specific for children? And then you have to ask, insofar as you're trying to get those under 18 to engage with controls and consents, you have to make sure there's no nudging behavior, not unduly encourage them to do anything. So, and then finally, there's going to be a lot of expectation for all organizations processing the data of minors to have their compliance documentation in place. So there'll be particularly onerous requirements and high expectations. What do I mean by compliance documentation? At its most obvious, your record of processing and having DPIAs for processing activities that comprise the processing of data about minors. So I just wanted to kind of put that, in front of you, and it's something you should certainly take away today and ask yourself, what data of those under 18 are we processing? Have we got special safeguards? Has our privacy policy been tailored? And just be mindful of developments at a regulatory level this year. Speaking of the current times we're in and shifting from kind of minors, Oisín, we'd have to mention Brexit before it's fully gone. So do you want to just talk about the implications of the current arrangements between UK now that Brexit has occurred?
Absolutely. So everybody's favorite topic. Unfortunately, I think we're going to be talking about this one for a while yet. So, yeah, as everyone knows, on New Year's Eve last year, the transposition period for Brexit ended. What that effectively means in practice is that the UK no longer has the special relationship with Europe, and they're on their own, subject to the new trade and cooperation agreement. There's a huge amount in the Brexit agreements. It almost broke my laptop when I tried to open the treaty. I want to focus on the data protection impacts, and I want to just focus on 3 specific points, what I think are the 3 practical takeaways here. The first point, as everyone knows, Brexit's happened. What this means effectively is that if you've got a business in Ireland and you're doing business in the UK, your paperwork and red tape and bureaucracy requirements have gone up. Effectively, you are now under the dual regulation of both the ICO in London and also the DPC in Ireland. You also might have some weird additional requirements that might come up, like you may need to, if you don't have a physical presence in the UK, but you're selling to people in the UK, you may need to actually appoint a representative in the UK. So just a lot of weird kind of bureaucratic things that are coming out that I think we're going to be dealing with for the next year or so. Second big takeaway is what I'm referring to as the stay of execution. So Philip talked about transfers earlier and the fact that transfers are getting much more difficult. Well, the UK is now a third country, which means that transfers from Dublin to Belfast technically would, but for a certain provision, ought to be treated in the same way as transfers from Dublin to Hyderabad or Dublin to San Francisco. You need model clauses, you need to jump through a bunch of hoops. Now, a stay of execution was granted to stop that state of affairs from coming into effect until either one, an adequacy decision is handed down, which effectively means the UK gets a stamp of approval from the EU, or until the middle of next year, or middle of this year rather. So key takeaway is that as of today, you can continue to send data freely from the UK, from Ireland to the UK, but that position might come under review or come under scrutiny towards the middle of this year, specifically 1 May or alternatively 1 July, assuming no one objects to an extension. Third point, and this is why I think we're going to be talking about Brexit in a year's time. There is a widespread assumption that you see, particularly from UK politicians, that the UK is going to get an adequacy decision from the European Union. I am much more skeptical of that for a variety of reasons. If the UK got an adequacy decision, it means the data could flow freely, everything would be happy. The problem that I see is that the UK has a very robust signals intelligence framework and has some fairly explicit law in this area, particularly the act known as the Regulation of Investigatory Powers Act. Now, if you go back to what Philip talked about around the Schrems 2 case and transfers to the US, the problem with the transfers to the US that we're encountering at the moment isn't US privacy law, it's US national security law. Now, the UK also has a very robust national security framework. So I think that before the UK gets an adequacy decision, there's going to be some serious debate over the safeguards contained in UK's national security law and whether they actually afford sufficient protection for the personal data of Europeans. So I don't think it's a done deal that the UK is going to get an adequacy decision. I actually think it's going to be politically very sensitive. One other point I just note briefly here is there is a certain political irony, which I would note, which is that when the UK was a member of the EU, their national security law was exempt from oversight from the European Court of Justice and the European Commission by virtue of the EU treaties. The Treaty on European Union expressly carves out national security matters to the member states. There is an irony that now the UK has left the EU, that their national security regime is going to be under the direct scrutiny of the European Commission and the court. So honestly, unfortunately, I think we're going to be talking about this one next year, but it's going to be a lot more developments here to watch over the course of the year. Finally, Philip, let's talk about cookies, the other big development that we saw a lot of over the course of the last year.
Yeah, for sure. Yeah, I mean, if you look across the team at Mason, Hayes and Curran doing data protection work and related work, I mean, a significant amount of folks have been working, assisting our clients in relation to cookies and related technologies that they use over the last few months. As users of the internet and apps, you might also have noticed that there's just been a lot more cookies notices and endeavors to capture consent. So the question arises, well, why is that? Principally from an Irish perspective, the big development, again, going back to guidance, was in April of 2020, where the DPC published the guidance note in relation to cookies, which was fairly timely because for a number of years, people were a little bit unsure as to where the rules in relation to cookies stood in light of the GDPR laws, because they're slightly separate laws, albeit they intersect. But in a nutshell, what the guidance said from the DPC is that the type of cookie banner, which a lot of organizations were using up to then and are using, many are still using today, is not satisfactory for capturing consent from users to use cookies. And rather what the DPC said is, in order to capture consent, which is required by the e-privacy regulations, consent must be a positive sort of clicking of accept to cookies. And also you must be consenting to these cookies on a per purpose basis. So consenting to cookies for analytics, consenting to cookies for other functions as well. So that's a much more onerous obligation than simply having a banner that you X out of. So that was the position in April. And the question then arises, so what have we seen with new guidance? Where's the enforcement? And while a lot of companies, as I said, are improving their practices based on the guidance, we haven't seen much enforcement yet. However, we predict that there is going to be a significant amount of DPC engagement on this issue. One of the reasons there's no enforcement yet was because the DPC said there would be a 6-month period to enable organizations based in Ireland to get their practices up to speed. That would have expired in October 2020. So we're now out of that grace period. So for that reason, we do expect DPC to be engaging with organizations. I mean, one tool they might use or technique is whereby they conduct a sweep. So they might write to like 25 or 30 large kind of organizations who have prominent websites and ask them a series of questions, and simply based on answers and analysis, select a subset of them to engage with. Another interesting point around cookies, and perhaps explains why traditionally organizations have been a little bit slower to get their compliance optimized, is because the GDPR fines of 2% and 4% that we talk about occasionally don't apply to cookie consent, because that sits in a different set of laws, namely the e-privacy laws. Does that mean people should be complacent? No. A, because the DPC can do other things in terms of it as other enforcement tools. And secondly, if you're an organization and your website is accessible from other countries and you have users or customers in other countries, you're also subject to the local laws of those countries when it comes to cookies. There's no one-stop shop as there is for GDPR when it comes to cookies laws. So for example, Amazon considered their main establishment to be in Luxembourg. Google have considered their main establishment for GDPR purposes to be in Dublin. Despite both of those positions, Amazon was fined, I think, 35 million, and Google was fined 100 million before Christmas by the CNIL, which is the French regulator for unlawful cookie practices. So as an Irish organization, if you have reach vis-a-vis your website or your apps outside of Ireland, well, you need to think about compliance with the laws throughout Europe, where GDPR fines may apply depending on how the local laws in relation to cookies are transposed. So look, for now, it's simply one to watch. And if you haven't considered the DPC guidance, you certainly need to go and take a look at it. So that's it on the GDPR privacy side. What I want to do until we get to Q&A, I want to hand you over now to Claire and Rowena. And I guess one of the reasons I asked Claire and Rowena to join is, again, looking at trends in 2020. And one thing we found on the data protection team was that we were engaging more with our kind of compliance and governance colleagues outside of the data protection team because of the confluence of some of the issues around risk management and compliance. So for that reason, we invited Claire and Rowena to join. So Claire, I'll hand it off to you if you want to take it from here. Thanks.
Thank you, Philip, and good morning, everybody. So we'll step away, but just briefly, from data protection laws. And I want to do this just to set the context for the next part of our discussion this morning. As all of you will know, the directors of an Irish company are the people who are responsible for the management of the company's affairs. So with this responsibility comes a series of important duties that they owe to the company. And included in these duties are duties to act in what the director considers to be in good faith, in what the director considers to be the best interest of the company, a duty to exercise their powers only for the purposes allowed by law, and when controlling and directing the company to exercise the care, skill and diligence which would be exercised in the same circumstances by a reasonable person with similar knowledge and experience to them. As you all also know, directors of a company have a duty to ensure that they and the company and its employees comply with a wide variety of legislation. Directors can have civil liability where the company suffers a loss or the directors make a profit arising out of a breach by them of their duties. but directors can also have criminal liability where the company commits an offence under statute and it's proven that that offence was committed either with the connivance of the director or was attributable to any neglect on the part of the director. So in exercising care, skill and diligence when controlling and managing a company, and also to manage the liability of the company and their own personal liability, directors must obviously be aware of the risks that the company faces and the steps that the company is taking to mitigate those risks. So from this, it follows that the directors must also understand the legislative and regulatory frameworks that govern the sector or sectors in which the company operates. They must be familiar with the requirements of these legislative and regulatory frameworks, the expectations of regulators, the company's level of compliance, and any risks faced by the company and them personally for any areas of possible non-compliance. So at this point, we'll move back to data protection. Where we have a company that's a controller of personal data, as all active and trading companies are, the board will likely be the body of individuals with ultimate responsibility when it comes to data protection compliance in the organisation. The GDPR implicitly supports this. For example, in Article 38.3, it provides that the DPO shall directly report to the highest management level of the controller. And under Irish law, this will be the board where the controller is a corporate. So where an organisation is a data business or where it relies on data to run or manage aspects of its business, including to compete, the directors really need to be taking responsibility for the organisation's data protection compliance and considering and managing its data protection risks. And a possible additional risk for organisations in the context of their data protection compliance is that the regulatory framework in this sector is at a comparatively early stage when considered in the context of other sectors, particularly the financial services sector. So given the responsibility that rests with directors regarding data protection compliance, what can they learn from an industry that has long since existed subject to a strict regulatory regime? Rowena, as your area of expertise is financial services regulation, what is the central bank like as a regulator and how do they approach their role?
Hi, thanks Claire, and good morning everyone. So obviously Claire is asking me that question because I'm a partner in our financial services regulation practice, and my practice is very broad, so I'm very familiar with, say, the central bank's approach as a regulator, both from their approach to granting authorizations and then how they interact with regulated entities on an ongoing basis. And what I would say in terms of approach, and I'd expect those in the audience today who are working in regulated financial services providers, I'd imagine you'd agree with this, would be that the central bank is very hands-on as a regulator. And some firms can find that approach quite intrusive. The central bank sees their role as being a gatekeeper with a specific mandate for consumer protection and financial stability. And it takes that role very seriously. Its scope covers everything that a regulated entity does. So, aside from data protection issues or breaches, they cover everything that a regulated entity does, and particularly how that impacts the regulated entity's customers. To the extent of a firm's interactions with the central bank will be directly linked to what's called their probability risk and impact system rating, or their PRISM rating. And this works on a sliding scale. So the higher your PRISM rating, the more attention you're going to receive from the central bank. And as a regulator, they tend to regulate by carrying out a number of themed inspections during a year. They'll pick a topic at the beginning of each year, and then they'll review that across particular areas of financial services regulation. And they also gather information from firms through various online reporting mechanisms, as well as ad hoc reporting when there's material issues or breaches by an entity. And the way they approach regulation, they're very focused on policy and procedure, so having robust procedures in place to deal with various issues, and importantly, following those procedures that a firm has put in place. And they're also really focused on having appropriate systems and controls in place in order to manage and mitigate risks within a regulated entity. So Claire obviously touched on risk management there, and that's a very much a key focus for the central bank. And they tend to expect that a 3 lines of defence model is adopted by regulated firms in order to manage the risks within their firms. And what 3 lines of defence means is that firstly, you'd have your relevant business unit that's looking after the day-to-day within their particular area of activity. Then you likely have some oversight from maybe a risk function or a compliance function that will review those risks and consider whether the first line of defense is keeping those under control. And then thirdly, you have an internal audit function who will carry out a risk-based reviews and general audits of the other entity or the other divisions within a firm. And they'll have overall responsibility for providing assurance to the board of the entity that the general governance and control framework of the firm is effective. So that's just a really, really high level idea of how the central bank approaches regulation. But Claire, I suppose turning back to you, for firms that maybe operate outside the financial services space, particularly those that rely on data to run their businesses, what kind of maybe risk management and compliance standards do you think are expected?
Thanks, Rowena. So let's look at the GDPR and the approach of the DPC here. The GDPR describes mostly in general terms what controllers must achieve in terms of accountability for processing personal data. So it requires controllers to implement appropriate technical and organizational measures to ensure and to be able to demonstrate that processing is performed in accordance with the GDPR. But the GDPR doesn't prescribe what those technical and organizational measures must look like. We also know that the DPC recognises the need to defer to the autonomy of controllers in terms of how they honour this accountability principle. The DPC acknowledges that the GDPR adopts a risk-based approach whereby accountability is delegated to controllers in a flexible way, because being intimately familiar with their processing, they're best placed to ensure compliance with the relevant provisions of data protection law. And by extension, best placed to manage the data protection risks that their organisation faces. So we've looked at the 3 lines of defence model, and we know that supervisory authorities around the globe typically consider it to be best practice for risk management and internal control. And as you've explained, Rowena, this risk management model is based on a strict segregation of duties. But if we consider this model in the context of digital innovation, it doesn't feel like a fit. New technologies, by their very nature, are not fully regulated, and a compliance department will struggle to measure irregularities and internal audit to measure the effectiveness of controls where this is the case. Segregating compliance from innovation as a separate layer of control might also not be aligned with privacy by design, which is itself a GDPR risk management tool. Instead, including compliance from innovation, including the compliance experts as part of the innovation, part of the design team, actually allows for responsible innovation. It allows for data protection and data processing procedures to be actually integrated into the technology itself, thus supporting the privacy by design approach. So what does this mean in practical terms? It means that the GDPR and the DPC don't require that risk management models applied in other sectors, such as the 3 lines of defense, must be adopted by technology companies to manage data risks. The GDPR instead affords organizations flexibility in implementing risk management and compliance controls that ensure that they're able to demonstrate that processing is performed in accordance with the GDPR, but in a manner that corresponds to the particular risks and particular needs of their businesses. And there actually seems to be little, if any, disagreement between regulators, leading academic commentators and controllers on this point. Moving away now from the management of risks associated with data and considering the risks associated with IT and cybersecurity, Rowena, the central bank, given its mandate in terms of financial services regulation, sets a high bar for firms when it comes to the use of technology and security. Is that fair to say?
Yeah, that's right, Claire. I think that the central bank does set a high standard for the firms it regulates. The risk associated with IT and cybersecurity are a key concern for the central bank, and an example of the standards that they apply here can be found in cross-industry guidance that the central bank published in September 2016. And these guidelines apply to the regulated financial services providers in Ireland that the central bank regulates. And these guidelines require that firms have sufficiently robust IT and cybersecurity governance structures in place to allow them to have effective oversight and to allow them to manage their IT risks. And that means that those firms should have policies in place, standards and procedures to deal with their IT risks. They should have clear roles and responsibilities for managing IT risks within their firms. And there should be some level of independent assurance carried out on the effectiveness of their IT risk management. And then when it comes to cybersecurity, the central bank expects firms to carry out cyber risk assessments on a regulated basis. They expect firms to have processes in place to classify data, enabling the firm to identify sensitive, valuable and critical data that the firm deals with. Firms should be able to manage access to their IT systems and have process to monitor their information systems, and also have a documented cybersecurity incident response plan. Importantly, the guidelines also require that firms notify the central bank when they become aware of an IT or a cybersecurity incident that could have a significant adverse effect on the firm's ability to provide services to its customers, or on its reputation, or on its financial condition. So, regulated entities or regulated financial services entities need to be mindful that there's a potential for 2 notifications in relation to data breaches, one to the central bank and then one to the DPC also. And then maybe if we look at kind of fintech firms a bit more closely, obviously the central bank's focus on adequate IT and cybersecurity will be more pronounced for those types of firms. And we see that as a key focus as part of the authorization process for new entrants, particularly in, say, the payment sector and the electronic money space. And there is a clear focus from the central bank around protecting sensitive customer information. And with general move to online and technology-focused products and solutions, there's deliberate regulation by both the central bank and the EU to protect the information that regulated entities hold. So, for example, strong customer authentication in line with PSD2 is now mandatory for banks and payments firms, as well as the directive on security of network and information systems. That sets a baseline for cybersecurity standards across all sectors. And in one way, because the central bank in Europe are, I suppose, quite prescriptive when it comes to the regulation of financial services, it means that to a certain extent, the standard for regulated financial service providers is somewhat clear. But Claire, I suppose maybe turning back to you again, for firms that operate outside of, say, the financial services space, is there any advice you give those firms?
Thanks, Rowena. So the GDPR at Articles 32, 33 and 34 does describe, again in general terms, the standards expected of both controllers and processors in securing personal data. Controllers and processors are expected to adopt a risk-based approach in implementing security measures that are proportionate to the particular risks that are presented by the type of processing undertaken by the organisation. And as we've already discussed, albeit in a slightly different context, to do this properly, the boards of controllers and processors must understand the security risk that their organisation faces. And obviously of relevance to this will be the position taken by regulators when dealing with security issues, particularly security breaches. Now, Oisín has given us an awful lot of background and detail on this, which is extremely helpful. And as he's shown, trends are starting to emerge on the consequences for controllers when there's a security breach. And while fines are being imposed, very large fines haven't been seen, but it's clear that regulators in some EU states are more active than others. There also seems to be a lack of consistency in terms of how fines are being calculated and assessed. And also Oisín has explained the response of the DPC to the Twitter case and aspects of which that were unexpected. So I guess by contrast to the financial services sector, as this is an evolving space, organisations need to continually observe developments and adapt their practices and structures as might be required. And I suppose on the train of what happens, in terms of enforcement action, and Rowena, how does the central bank react?
Yeah, I think the central bank has really broad powers of sanction and investigation, and what we've seen on, say, my side of financial services regulation is that the central bank isn't afraid to use those. Its powers are based on a statutory footing, and in short, when a regulated financial service provider carries out or commits a prescribed contravention, the central bank can issue various types of sanction on them. And what's considered a prescribed contravention is quite broad, and generally speaking, it includes any breach of, say, financial services regulation or legislation that an entity is subject to, as well as a breach of or a failure to comply with any codes of conduct that might be issued by the central bank. And the types of sanction that the central bank can impose range from, issuing caution or a reprimand on an entity, disqualifying an individual from a particular position, issuing a direction to carry out a particular activity or to cease a particular activity. But the one, I suppose, that gets the most press and publication really is the monetary fines that the central bank can impose, and they can go up to 10 million for corporate bodies, or 10% of their turnover, or up to 1 million euros for natural persons. So, that's quite significant. And the central bank has taken a number of action over the years. And most recently, and probably most relevant for the audience here, is in July 2020, Bank of Ireland Private Banking was fined over 1.6 million euros for a cyber fraud incident that they were involved in. And amongst other things, the central bank found that Bank of Ireland had inadequate systems and controls to minimise the risk of loss from fraud for its customers. And in that particular instance, the bank acted on the instructions of a fraudster impersonating a client and made 2 payments to a third-party account, totaling over 100,000 euros. And on foot of this enforcement action and the settlement arrangement entered into with the bank, the central bank was really strong in their messaging. And they pointed out that firms really have to be alert to the increasing threats from cyber fraud and to the security of, say, their clients' deposits, as well as confidentiality of their clients' financial information. And the central bank really emphasised that firms must put in place appropriate safeguards to protect their clients. Also, in June 2018, there was an action taken against an asset manager for failing to protect client assets against fraud. And in that instance, there was a fine of over 400,000 euros imposed on the entity. And the thing here is that the examples I touched on there could have well have been investigated by the DPC also. So again, you can have one instance with 2 regulators looking at, and I think that really underscores the importance for good compliance frameworks within all categories of entities. And only in March last year, the central bank published a report detailing its findings from a thematic inspection into cybersecurity risk that it had carried out in asset management firms. And the findings that the central bank published are relevant for everybody. The central bank found that boards and senior management were not prioritising a strong culture of cybersecurity within their firms. The central bank found deficiencies in IT asset inventories. And the central bank found that cybersecurity incident response and recovery plans weren't meeting their expectations. And they also found that the quality and frequency of cybersecurity risk reporting was variable amongst firms. So I think from my side, a key takeaway from firms in terms of governance has to be that the central bank expects boards and senior management oversight in respect of the management of IT risks and cybersecurity risks within their firms, because ultimate responsibility rests with them. So handing back to you, Claire, I think as head of our corporate governance department, you have significant first-hand experience in appropriate governance structures. What advice would you give the audience on this piece in the context of management of risks associated with, say, the protection of data?
Thanks, Rowena. So just very briefly to sum up, I guess, to conclude this discussion, we've discussed the fact that the board of an Irish company is the body of individuals with ultimate responsibility when it comes to data protection compliance in the organisation. We've also discussed that while directors must ensure that their organisation implements appropriate technical and organisational measures to ensure and be able to demonstrate that processing in their organisation is performed in accordance with the GDPR and the DPC don't prescribe how data risks are managed and compliance achieved once an organisation can demonstrate that this is being done. So again, back to this point that this affords the board of an organisation flexibility to adopt compliance structures and risk management measures that are commensurate with the risks to their users. So let's just briefly take a practical example. At the heart of the management of data risks is the manner in which organisations make decisions relating to the purposes and the means of processing of user data. The nature of some businesses requires them to be able to make these decisions continuously and frequently. These decisions are ultimately that organisations and many organisations' business decisions. So they're extremely important. And it's obviously back to the board to be responsible to take responsibility to ensure that these decisions are made in accordance with applicable data protection laws and following a consideration of the risks, particularly to users. And where there's a volume of decisions, the board is not going to be able to make all of them. And the board doesn't need to make all of them. It can delegate its authority to do so. But important when any delegation is being made is that the board can delegate its authority, but it can't delegate its duties or the responsibility for the proper fulfillment of those duties. This means that the directors, in delegating some of their authority, have a duty to ensure that the authority delegated is properly exercised, and the directors remain accountable for any misuse of the delegated authority. In order for directors to be able to successfully balance the management of a company through effective delegation, and on the other hand, their obligations of accountability and responsibility, and not forgetting their own personal liability, they need to clearly articulate the scope of any delegation, and they must actively make the persons to whom they delegate authority accountable to them. What might this look like in terms of a governance model designed to ensure that decisions relating to the purposes and means and processing of user data are made other than by the board, but in a manner that complies with the law and also that protects the company and its directors? So what might this look like? The board will firstly delegate authority to make certain decisions, but it'll choose the delegates carefully. They'll be experienced and senior people who understand what's being asked of them and who are qualified to make the decisions. Now, the board must continually oversee the risk management of decision making. It must prescribe how decisions are referred back to it, the escalation model, if you like. And it should also approve any risk assessment processes that the decision makers apply to decisions, particularly to determine if they're high risk decisions that should be coming back to the board for consideration. The board should also prescribe the manner in which the decision process is taken to make sure that decision makers are consulting the correct experts and have the correct experts available to them so that decisions are made in a properly informed manner. There also needs to be a means for the decision makers and others in the organization who are involved in the process to understand the importance of following the process and the issues and difficulties for the board if the process is not followed and issues follow. Those that are involved in the decision-making process need to be reporting to the board with reasonable frequency on the decisions or certain of the decisions that are made. The board should have the opportunity to question the reports that are made to them so that they can understand the outcome and impact of those decisions and also allow themselves to spot deficiencies in the process. And compliance with the process needs to be monitored, but through proportionate means. This could include with the assistance of the organization's data protection officer, but it doesn't necessarily mean that there needs to be an internal audit function. The board also needs to review the process at least annually, just to ensure that it is still working as it should, and also to revise it as it might need. The board needs to participate throughout the life cycle of this regime, and it also needs to minute its participation. And obviously throughout the process, the organization's data protection officer will retain the critical role envisaged for it by the GDPR to assist and advise on all issues relating to the protection of personal data. I went through that very quickly, but there's plenty to consider in this space. I'm also conscious we're up against time, so I'm going to hand back to Philip now, and thank you all for your attention.
Great. Thanks very much, Claire and Rowena. Yeah, perhaps we would I'm going to do, if folks can stay on for 5 minutes, I promise we'll wrap at 12:05, and I can see we still have very good attendance. First, could I just have a quick look at the poll results, and let's talk through them really quickly. We asked 3 questions. Thanks. I think 166 people responded, so about 1/3 of you responded. First question: has your organization changed its cookie policy or banner? And it seems that the majority of organizations have addressed this in the last year. That's really helpful. 40% haven't, so strongly advise those 40% to go back and to dust off the new guidance and consider making some changes. What's the biggest risk presented to your organization? What do you perceive it to be? And I think the answers here to question 2 are very interesting. I mean, overall, I think organizations and those who answered are focused on the correct things, which is international data transfers and the lack of internal compliance issues, along with security breaches. So I think the focus is correct, so keep it up. Finally, in relation to minors, majority of you haven't engaged with the issue of minors in much detail in your organization, according to this poll. So again, advice is this is definitely something. There's just 3 takeaways from this seminar. I would certainly take that back to your organization and take a look at what you're doing with data of those under the age of 18. That's it in relation to the poll. I'll just do 2 questions perhaps, or 3 maybe. I'll ask Claire, I'll ask Oisín, and I'll take one for myself. Claire, starting with you, I'm asking you this because I get asked this question a lot as well, but you answer it better than I do. It's what are the risks for directors of an Irish company where the company commits an offence under the applicable data protection legislation, so personal liability?
Apologies, I started much better there than I'll probably do now. I'll actually just look at the Data Protection Act, and we might just look at section 30, which actually relates to the processing of personal data of a child. And it explicitly states it's an offence under the Act for a company or corporate body to process the personal data of a child, and it goes on into a little more detail. And I'm not going to opine on exactly what that entails. So this is a prescribed offence under a piece of legislation, and the Data Protection Act also says that a director can have criminal liability where the director's company commits an offence under statute, and it's proven that the offence was committed either with the connivance of the director or was attributable to neglect on the part of the director. To be exonerated from having criminal liability, a director has to show that they took all reasonable steps to stop the offence from occurring, but due to circumstances beyond their control, they were unable to do so. So the importance of what we need to consider here is it will be an offence if statute prescribes it's an offence. It doesn't mean that every single breach of every piece of legislation will lead to the company committing an offence and by result the director committing an offence. In a case though where it's proven that the offence was committed either with the connivance of the director or because they were neglectful and did not know they should be doing something, or when it were inadequately supervising a process, they will be deemed to have committed the offence as well. And it's on the director then to demonstrate that they took reasonable steps to stop it from occurring, but weren't able to do so. And that'll be the importance of board minutes and active activity by directors, knowing they have a responsibility and accountability to achieve a certain standard and doing what they can to achieve that.
Very good, thanks. Oisín, quick one for you. Just a couple of the questions that came in concern Brexit and this issue of the Irish organisation that's doing business in Ireland and into the UK, working out, what laws will apply now going forward, and who is the regulator, or if there's a breach covering Ireland and the UK, might there be implications under 2 regulatory regimes? If you could give us a quick answer to that.
Okay, I'll be as quick as I can. So effectively, if you're an Irish company and you're providing services into the UK, you're probably subject to both Irish and UK law at the moment. You're under Irish law because you're based in Ireland, and you're under UK law because you're providing services into the UK, and post-Brexit, UK law is going to apply to you in addition. The other kind of issue that arises here is, well, what happens if the 2 regulators say different things? And I saw one question to that effect pop up. The answer to that, unfortunately, is tough. It's a fairly unsatisfactory answer, I know, but the problem is you've now got 2 kind of separate legal systems that don't talk to each other, and don't have a way of resolving conflicts. So you would hope that you would try to deal with this informally. Maybe the regulators would chat informally, but there was a process pre-Brexit to deal with these sorts of conflicts. That's gone now. So all in all, it's challenging. One other kind of related issue, so I'll pop up a bit, was around the obligation to appoint a representative. Effectively, that's going to arise if you don't have a presence in the UK, but you provide goods or services into the UK to individuals in the UK, or you monitor the behaviour of people in the UK. And then there's some technical issues around what it means to have a presence. Technically, it's an establishment. Honestly, it's a fairly lightweight test. So I think if you have some substance in the UK, some physical substance, you may be exempt from this representative rule. But subject to UK advice, what I would usually tell people is that in their privacy policies, they should make clear that they have a presence in the UK, because otherwise a UK citizen or a regulator reading the privacy policy will think they're in breach of this obligation to have a representative. So it's a bit of a dog's dinner, to be honest.
Yeah. Super. No, that's great. I think it's really, again, another takeaway for folks just to consider their UK compliance. Okay, I mean, before I wrap up, there's one tiny point I want to address. We talked a lot about SECs and the difficulties with using SECs. The question arises, well, can one use BCRs in the alternative, and does it work around some of the problems with overseas laws? The answer is no. The guidance that's coming from regulators, which we would agree with in this regard, suggests that the same underlying issues which challenge the use of BCR, such as government access overseas to European customer and user data, will also these challenges arise in the context of binding corporate rules as well. So they're not the panacea to the challenges that we have. Anyway, that's it. We better wrap. Look, thanks very much for your attention, and for the vast majority of you who are still with us. Hopefully next year we'll be all back in Shelburne and having with croissants and coffee. In terms of wrapping up, there's a survey going to appear once we wrap on your screens. If you don't mind, fill it out. We'd really welcome your feedback. And we have made a recording of this seminar if you feel like watching it again. So we'll make that available to you soon. That's it. So yeah, once again, thanks very much. And we look forward to staying in touch with you. Thanks. Goodbye.